The Mad Hatter here with part 20 of the My Docket series on Corazon real estate, day after Halloween and still going. We have the affidavit regarding, actually, no, that is a document in this video, but that's just one of the ancillary documents. Motion to require Corazon Real Estate to pay the cost of filing. I guess that's going to be what we go ahead and lead with, and I go into the amended complaint that they file. But I guess mindset is good. I just got an order reversing. The case is opened up again. They've got an attorney. They do get an attorney in this video, and things start to move forward. I remember feeling good. I remember feeling like the case was back on track now. Hopefully the judge would give me the respect that I should have had from the first place. Hopefully he'd realize that he messed up. And I mean, I don't know what else to tell you other than this was good. It went from a case that was over to a case that's back open, and that's very favorable to me. I can't remember much else besides that, and so I think at this point in time, let's go ahead and take a look at what I have filed. Here we have the motion to require Corazon Real Estate to pay the cost of filing fees. You know, I talk about this in the video form of Papyrus. Please watch my video on the topic form of Papyrus if you want to learn more about what I'm doing. If you win, what the court is supposed to do is order the losing side to pay the costs that they would have paid had you posted them directly to the court. That's what's supposed to happen. On multiple occasions, I've tried to get this to occur, and there's only one judge who's actually followed the law, and that's Justice of the Peace Scott Pearson. The other judges that I've tried this with did not follow the law. District Court Judge Chuck Weller, I think he said that I waived my right to do this, which is weird because that's the money that the government's entitled to. That's not my right. So I don't know how I can waive the government's right to collect those monies. I think he just didn't want to order it, and so he just cooked up some kind of bogus reason. In any event, factual background. I filed a complaint. The defendant filed an answer. I filed a motion to require the defendant to obtain counsel. The defendant filed a motion to dismiss. Parties filed responsive pleadings. The court committed reversible error in granting the defendant's motion. Chief Judge David Hardy had granted me form of Papyrus status. A panel of the Supreme Court of Nevada unanimously entered an order reversing the decision. And then I filed a memorandum of costs in the Supreme Court, taxing costs, legal analysis. We've got Rule 39 sub E5. The costs of filing the appeal is taxable in the district court. When a forma pauperis litigant prevails, costs that would have been paid, if not waived, are redirected to the court itself. And that's a statute, 12.015. Actions involving indigent persons. If the person prevails in the action, the court shall enter its order requiring the losing party to pay into court within 5 days the costs which would have been incurred by the prevailing party, and those costs must be paid as provided by law. In accordance with the doctrine of statutory construction, the award of costs of the court is mandatory. If you want to learn more about why this is important, please watch my video on the topic, statutory construction. When the prevailing party is determined under Rule 49 sub A3, the court must extend the doctrine of statutory construction to court rules. They talk about this in multiple cases, that the principles of statutory construction apply to court rules. I'm not requesting a hearing on the matter. I'm asking that Corazon Real Estate is ordered to pay $250 in costs to the Second Judicial District Court within 5 days. Rule 5, Certificate of Service, indicating that this document was personally served to Corazon Real Estate. List of exhibits, order of reversal, Exhibit 1. And here's the order of reversal that we'd already went over. Standard policy in the My Docket series is that I do not go over the same document twice or more times. But you can go down into the description below, click on the link, download it for yourself, take a look. If you think there's something that I missed, definitely bring it up, mention it down in the comments, and I will go ahead and discuss it. But again, guys, I went over this order in the last video, so all you have to do is watch part 19, and you'll be able to see my analysis on the order of reversal. Affidavit regarding ghost lawyering. I don't know that this came up. Maybe I just assumed, or maybe there was an email that was sent to me by the lawyer or something. And so just kind of to nip it on the bud, I filed my affidavit regarding ghost lawyering. I already did this with Judge Chuck Weller. He's a judge who thought that I had a secret attorney helping me. So I probably assumed that this judge would think the same thing, and I'm just letting this judge know there is no ghost lawyer. It's just me. Rule 5 certificate of service indicating this document was mailed to Corazon Real Estate. In hindsight, I don't think I would have filed this. If the court brings it up, file it. If not, don't file it. It's just an extra document. Just wait and see what the court thinks. Amended complaint. So this is my amended complaint. Sorry guys, I thought I mentioned something was filed by the attorney, but I guess it's next video, not this video. My amended complaint, if I remember correctly, I very briefly went over this when I filed the motion to amend. How does this work? Oh, I see. Okay, interesting. So there is a rule. It's Rule 15 sub A, and that rule says that when the defendant makes an appearance, you're supposed to ask permission or get a court order to amend your complaint. You cannot do this without the defendant's permission or an order from the court. But the Supreme Court's order strikes all of Charles Chinichi's filings, which would include his answer. It renders everything that Charles Chinichi has done void ab initio. Retroactively erases all that stuff. So what I'm saying is that since there no longer is an answer filed because it's just been erased from existence, I don't need his permission. I can just amend now. So I just amend my complaint. Just like that. Just the rules of civil procedure allow you to do that if an answer hasn't been filed. At least they did back then. And I think they only allow you to do it once. Maybe, you could take a look yourself, guys. If you want to learn how to research this stuff, watch my video on the topic statutes, rules, and case law. Parties. So, wait a minute. I'm not going to reread this if it's just the same. I'm going to look for the parts that have changed. I think I italicized it. I don't see anything new. Interesting. Maybe I discussed it when I went through the motion itself. If I remember correctly, I added a few things after move out, like the security deposit withholding and wrongfully charging eviction fees. These two things possibly are added. Okay, and then this here, move out. On move out, I was charged $40 for general cleaning. So basically, while the lawsuit was going, I moved out, and then I got charged a bunch of stuff, and so I'm bringing that up. But other than that, it should be the same. You guys, this is a pretty important document. It is a pleading, and I talk about the importance of the complaint in a video titled The Complaint. So definitely watch that video. It's 100% extremely important must-watch video. Verification, I'm indicating that this complaint is true and correct under penalty of perjury. And then we got Rule 5 certificate of service indicating this document was mailed to Charles Chinichi. Oh no, personally served upon Charles Chinichi. Going into the aftermath, I filed 3 documents. They were all free filings. I think they were anyway. I might have had to pay to file that amended complaint, and I can't remember. If I did, I doubt it was the same price. It might have been like $30, $40, something negligible. In any event, I filed 3 documents. They were probably free filings, so I probably incurred $0 in costs. If I didn't, it was a low dollar amount. And then the Charles Chinichi didn't file anything, so he incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. And Charles Chinichi's attorney would have reviewed these documents when he's eventually forced to hire one, which should be next video. And I don't imagine he would have spent more than 15 minutes on this at the rate of $250 an hour. That's going to come to $62.50 in attorney fees for Charles Chinichi. As for my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.